In 2013, you testified that Wyoming is, quote, a good example of a state that is doing an effective job regulating hydraulic fracturing. You testified that Wyoming has, quote, great sophisticated hydraulic fracturing regulations. Since then, Wyoming has only strengthened its hydraulic fracturing regulations. For example, we now require baseline groundwater testing before and after hydraulic fracturing takes place. It also requires additional disclosure of hydraulic fracturing fluids. Now, BLM is soon going to issue a final rule for hydraulic fracturing on federal land. Now, I question the need for BLM's role in states like Wyoming, which already regulate hydraulic fracturing on federal land. So my question, will BLM allow Wyoming and other states to apply for and obtain a variance from its rule so it can avoid duplicating state regulations?
Thank you, Senator Barrasso, and I stand by my comments. Wyoming has done a very good job in providing regulations that are forward-thinking, and we've learned from Wyoming as well as some other states. Our proposed regulations say that if a state's rule is stronger than the proposed federal rule, that the state's rule will govern, and that is, in fact, the case in some elements that you just referenced in Wyoming. I don't know that there is anything in our proposed rule that is more stringent than Wyoming's rule, so I'll have to look into whether a variance would be even on the table as it relates to Wyoming, but I think that we want to provide certainty to industry. We don't want to make the regulations complicated, so if that's something that the state would want us to consider, it's certainly something that I'd ask BLM to look at. The goal, however, is to provide minimum baseline standards, and many states are not sophisticated like Wyoming. These activities are relatively new. Their regulations have not kept up, if they have them at all. And so for federal and tribal lands, we're really looking at baseline standards, learning from folks like you.
Let me move to the Endangered Species Act. The Endangered Species Act states that you, the Secretary of Interior, shall by regulation determine whether any species is an endangered species or a threatened species. Last year, Congress passed the fiscal year 2015 appropriations bill. The bill states that you may not use any funds to write or issue a proposed rule for greater sage grouse. That's what it says. But last month, in a letter to Wyoming Governor Matt Mead, you wrote that the appropriations bill, quote, does not affect Fish and Wildlife Service's court-ordered obligation to make a determination by September 30th of 2015 as to whether the greater sage grouse does or doesn't warrant protection under the Endangered Species Act. So with all due respect, I can't make sense of your letter, and I find your plans to ignore federal law troubling. So the question is, please explain how you can list the sage grouse without first issuing a rule.
Thanks, Senator, and I know there are legal nuances that I am learning myself. We are required under court order to make a determination of whether a listing is warranted or not through the Fish and Wildlife Service. We would not have any funding to prepare a rule, so we have to make a determination by court order, but we cannot, if we make a determination that is threatened or endangered, and believe me, I hope we won't get there because of the great work that's going on with the states involved in the sage grouse. But if a listing were warranted, the Fish and Wildlife Service could say a listing is warranted, but they could not write a rule that indicates what that means. So we certainly fully intend to comply with the law, but it doesn't stop them from making the determination, just writing a rule that says then what.
So is it your view then that this so-called determination would be legally binding?
You know, I have to defer to the solicitors. It's a determination, but the rule is what would determine what happens next, and we are bound by court to make a determination and bound by law to not write a rule. So I'm working very hard to support the state's efforts and the federal government efforts so that a listing is not warranted, so we don't have to call the question on this issue.
I have a final question on this, your President Obama's so-called strategy to reduce methane emissions. As part of that strategy, the BLM plans to issue new regulations for venting and flaring of natural gas on federal land. Absent in the strategy is any effort to actually make it easier to get permits of natural gas gathering lines. Gathering lines are the pipelines which can collect and then transport that natural gas from wells to processing plants. They're necessary to reduce the venting and the flaring of natural gas, and we've introduced legislation in the past to make it easier to do those sorts of things. A principal reason why natural gas is vented and flared in the West is that BLM is failing to permit gathering lines in a timely manner. So if BLM gave the permits for the lines, that would reduce the flaring on and off of federal land. So do you know if BLM is trying and doing all it can to expedite the permitting of natural gas gathering lines, and what specific steps BLM has taken?
Yes, Senator, we are very committed to gathering the gas and not resorting to venting and flaring as is happening. I am not aware of circumstances where permits have been slowed down by the BLM, but I will say our resources are constrained. We're asked to inspect wells, we're asked to approve permits to drill, and we've had a real challenge in our budget with sufficient resources to do what's expected of us. So I would appreciate any support that you could provide in making the case for why it's important that we resource BLM appropriately, because we completely agree that the best thing to do with this natural gas is to gather it and sell it in the market.
Thank you. Thank you, Madam Secretary. Thank you, Madam Chair.